The levels of governance in immigration law are the same as we see in many areas of agency practice, but some things are relatively unique. At the top, we have, of course, the US Constitution. Any law in this nation that does not fulfill the requirements and the parameters of US Constitution will be thrown out eventually. Below, in dignity after the US Constitution, is the organic act, the act under which immigration law exists, which is Immigration and Nationality Act. Below that are regulations of each agency, and there's a whole bunch of them. We'll talk about that in a minute. So the agency regulations. Below that, the adjudicative process of the agencies, their decision making. Below that, their standard operating procedures. Each agency has its own name for their procedures. For example, AFM, Adjudicators Field Manual, is what USCIS uses as operating procedures for benefits. Department of Labor has its own. State Department has a Foreign Affairs Manual. Okay, so every agency has its own standard operating procedures. Below SOPs are the policy memoranda, and this is the part which is quite unique about immigration. This is one agency, USCIS specifically, that has been extremely reluctant to publish some very important regulations. So what they've started doing is, and they've been doing for several years, some very important areas of the law are governed by ad hoc memoranda rather than by fixed regulations. So you can imagine, you wake up one morning and you find out the face of the laws has been changed because there's a new memorandum out which radically alters the agency interpretation of how things are done. And there's an act called AC-21, American Competitiveness in the 21st Century Act. That act was promulgated back in October 2000. So we are now in the 12th year of that act. We still don't have regulations. This is a very, very important act for a lot of people who are involved in immigration through business and professions. But policy memoranda is all we have. And then there is that area of the law which is familiar to all agency practitioners, which is the gray areas. Nobody really knows what those, let me rephrase that, what the agency approach to a particular problem is unless you have actually practiced before the agency. So these are the gray areas of the law which are known only to people who have the good fortune or the misfortune of dealing with these agencies on a regular basis.